I'm Simon Mayberry. I'm Head of Employment Law at Balfour+Manson. I advise a lot of business owners, and I'm finding that frequently I'm receiving the same questions from them over and over again. And so I wanted to put together a couple of videos to answer some of those and give them an idea about what they might want to do in particular circumstances. The changes to the law on sexual harassment, effective from the 26th of October 2024, introduce a proactive duty for employers where they will have to take reasonable steps in order to prevent sexual harassment. And if they don't do that, then in the case of a successful claim of sexual harassment against an employer, they could face an uplift in compensation of up to 25%. Given that compensation is uncapped in discrimination cases, this could be really expensive for employers to get wrong. In practice, taking reasonable steps to prevent sexual harassment usually involves three things: having in place policies about sexual harassment, having training for employees in order to prevent sexual harassment, and taking action against those employees who are found to have committed sexual harassment. Very importantly though, employers can't let those policies or that training go stale, so generally speaking they need to try to revisit that every year or so. The question of whether employers should focus on diversity and inclusion is something that I hear all the time from business owners. And my answer is almost always exactly the same. There is only gain to be made by promoting diversity within a business. If you think about it, having as diverse a workforce as possible can only be advantageous because you're bringing in people from a wide variety of backgrounds. If you limit the number of backgrounds that you bring in employees from, then you're limiting the amount of different experiences that they have and that they therefore bring to the company. More and more now I'm hearing from employers that younger potential employees are pushing back on offers of employment because of the way that they regard the company. So it's important for employers to be seen as an employer of choice. So if business owners aren't paying attention to something that's important to a younger generation of potential employees, it stands to reason that they might lose out on some very good talent. There's often a criticism of some employers in some industries as being pale, male and stale. And really focusing on diversity, inclusion, equality, putting a positive value on diversity of background helps companies, helps business owners to avoid that. And the risk with having people coming from the same background is that you end up with just one way of thinking and everyone does things exactly the same way. Clients get in touch with me all the time about receiving grievances, and almost without fail, they panic about that. It's important for employers to realise grievances are a very common thing in employment law, and the first thing to do is not to panic. After taking a pause and not panicking about the grievance that they've just received, what employers should do is look at their policies. Employers often feel a little bit lost at this time, but the reality is, in the majority of situations, you will have internal rules that deal with this sort of situation. The vast majority of employers have a grievance policy. If you don't, then the ACAS website has a lot of really useful materials. A grievance is something that needs to be investigated, so it stands to reason as a company you need to put someone in charge of investigating the complaint that's been made. Ideally that would be someone who isn't involved in the complaint and that is at a relatively high level of management so they can take decisions. That person then has to go and investigate what has been said. That might be very clear, it might not be very clear. What they need to do is look at the wording of the complaint that's come in and assess, what do I need to look at here? Do I understand enough about what's being said? Do I have to speak to the complainant in order to get a bit more detail before I go off and do my investigation? When they start investigating, it's always useful for that investigating officer to think about the type of evidence that might be available. Are there any witnesses that I need to speak to? Is it one person's word against another? Is there any CCTV evidence? Is there any documentary evidence? Is there anything that's been captured electronically that I could look at in order to help me decide what's happened here, essentially? What happens next is usually a grievance hearing held by the investigating officer with the complainant. And at that hearing, The investigating officer will present the evidence that they have uncovered, present what their initial findings are, and allow the complainant to respond to that. What I think is very important and is often overlooked by companies is asking the complainant what they're looking to get from the grievance process. My experience is that a large minority of people who raise grievances simply want to complain. They simply want to shout at the employer. They don't know what they want from this, but they know that they want to complain. Those sort of situations can be sorted out by asking the individual, what is it you want from this? And if they don't know, often that grievance won't go anywhere. After collecting all the evidence, speaking to the complainant, holding a grievance hearing, the individual who's investigating the grievance needs to reach a decision. Very often that's a point at which they'll come and speak to me in order to take advice, in order for me to help them with the drafting of an outcome letter, because you will want, as part of a paper trail, to send a letter to the complainant. In that letter, you want to be very clear about the different heads of the grievance, what you found, and whether you're upholding that element or not upholding that element. And then overall, whether you're upholding the grievance, not upholding the grievance, or upholding it in part, and what you're going to be doing next about that. You also want to give the individual the right to appeal, particularly if you're turning down large parts or all of the grievance. The appeal procedure is likely to be covered in the grievance process. If it's not, again, look to ACAS. But generally speaking, what you need to do is find another individual to hear any appeal. That individual should ideally, again, be independent of the complaint and should also preferably be more senior than the person who investigated the grievance initially. Generally speaking then, you're looking for someone at the top end of the organisation. Now, often when grievances are brought by people who themselves are quite senior, you may find that you're running out of people within the organisation to hear the appeal. In those instances, it's quite common for business owners to look externally, maybe to an HR consultant, possibly to an employment lawyer, who can assist with the hearing of an appeal independently. The single most common inquiry that I get, and I get it a couple of times every week from business owners, is, I want to get rid of this person, how do I do it? And very often there are two main challenges there. Firstly, there might not be a potentially fair reason to dismiss this person. Secondly, there might be a potentially fair reason, but we have no paper trail, no evidence to show that something has been an issue for some time. Employers need to be aware that there are 5 potentially fair reasons for dismissing an employee. Those are misconduct, redundancy, capability, whether that's someone's ability to do a job or lack thereof because of training, or their medical incapability to do a job, some other substantial reason, such as to justify dismissal, and a statutory bar, so a legal bar to someone doing that job. At its most basic, if you don't have a potentially fair reason to dismiss someone, that dismissal is almost certainly going to be unfair. So the first step for me and for the employer is to consider, actually, does this situation fit into one of the potentially fair reasons for dismissal? Sometimes it doesn't. If it doesn't, I'm not a fan of trying to get a square peg through a round hole, making something look like a redundancy when it patently isn't, because that just comes undone at tribunal. If we do need to find one of those potentially fair reasons for dismissal in a situation where it's not clear, some other substantial reason tends to be the one where we would look. Some other substantial reason, commonly referred to as SOSR, is a sort of catch-all for types of dismissal that don't tend to fall within the other categories. It might be easier to give an example of an SOSR dismissal because employers tend to be unfamiliar with it. If you think, for example, of a cleaning company that has contract cleaners in lots of different office buildings for lots of different companies, one of those companies in an office building might take against a cleaner and say, we don't want them back in our office. At that point, the employer has a difficult decision to make, a difficult situation. They need to decide, can I push back and make the client change their mind? Can I put this cleaner elsewhere, another contract that I have? And if that's not possible, then you run out of options, and the only option might be a dismissal for some other substantial reason. We don't have anyone to put you with, we don't have any client for which you can clean. In an SOSR dismissal, the employer will want to consider, all alternatives to dismissal. They'll want to meet with the individual and consider whether there are any other roles that they could do within the organisation, whether they could potentially change their hours, work for a different client, all sorts of examples to try to avoid dismissal. But really the touchstone in all of this is reasonableness. Where it looks like the employer is out of options for a fair dismissal, or where they want to make a decision very quickly, but they perhaps don't have the evidence to support the dismissal and they want to do things safely, the best course of action for an employer is to consider a settlement agreement. A settlement agreement is essentially a contract to usually bring to an end a contract of employment. It's an agreement between an employer and an employee in which the employee will usually agree to have their employment terminated and to waive the vast majority of their potential claims against an employer. In return, the employer will give them something. It's usually a sum of money. It doesn't always have to be a sum of money. You can be as imaginative as you want in deciding what's going to be in that package, but the message to employers really is it has to be something that's sufficient to compensate the employee for terminating their employment and waiving their rights. While the majority of settlement agreements involve simply a cash payment and potentially a reference being given to the employee, it's important for employers to realise that they can be as imaginative as they want within the bounds of the law. Frequently I advise clients on settlement agreements where cash is not the most important thing or cash might not be available for the employer. For a lot of employees, the most attractive element of a package is cash, and employers can take advantage of certain rules on termination payments whereby the first £30,000 of any payment is free of tax. For other employees, depending on which stage they're at within their career, it might be less that they require cash immediately. They might want cash put into their pension, for example, which can take advantage of other tax efficiencies. The important thing for an employer is to consider what might be attractive for this employee, what's going to bring them to the table, and that's something that they can always speak to their employment solicitor about. Most settlement agreements will also include some sort of a reference, and it's important in that to make sure that the reference is factual. Now, a factual reference is dealt with by most employers as simply stating job title and dates of employment. Generally speaking, that's not a particularly useful reference for an employee. It looks like something that's come from a settlement agreement. But if you're going to go into more detail and give a glowing reference, make sure that's factual. Importantly, for employers, giving a reference is cash neutral, it's free, whereas it might be extremely beneficial for the employee to receive a really good reference. So always important for employers to think about that. It's also important for employers to consider how they initially introduce the concept of a settlement agreement to an employee. Nowadays, employers have the advantage of being able to use something called a protected conversation, in which they do not have to have any previous issues and can introduce a settlement agreement essentially out of a clear blue sky without warning to the employee. The advantage of a protected conversation is that it can't be relied upon if all goes wrong in an ordinary unfair dismissal claim. As a health warning, though, for employers, it can be relied upon in a claim of discrimination, for example, and therefore employers need to be very careful about their conduct during those conversations. Related to that, but somewhat different, are without prejudice conversations. Those are also off the record for unfair dismissal claims, but crucially, they also can't be used in court if everything goes wrong in, for example, a discrimination claim. The downside is that there has to be an existing dispute that you're trying to deal with and trying to settle, so you can't do it out of a clear blue sky like you could do for a protected conversation. In the bad old days, an employer used to just be able to sit an employee down in a dark room and say, sign this. That can't happen anymore. There are certain statutory obligations in order for a settlement agreement to be legally binding. One of those is that the employee has to have taken independent legal advice about the terms of the agreement and its effect on their ability to pursue a claim before a tribunal or a court. So they have to take independent legal advice. And as a result, given that most settlement agreements are brought forward by the employer, it tends to be that the employer will pay at least a contribution, usually around about £500 plus VAT in a straightforward case, for that legal advice for the employee. Given that employees have to take independent legal advice, you do often find that's the point at which a solicitor on the other side gets involved and maybe looks to try and negotiate the package upwards. What I tend to do is have my clients make sure that the employee agrees in principle to the package that's been offered before they're provided with a draft settlement agreement to take to their lawyer. That means that if the employee's solicitor comes back and tries to inflate the package that's on offer, it's much more straightforward for my client to say, no, that's not happening. Your client agreed to this in principle, and therefore the options are sign it by a deadline or it's off the table. That puts the employee solicitor in a difficult position. Do they want to cost the employee the entire potentially very generous agreement for the sake of a couple of extra £1,000? Probably not. In my experience, a lot of solicitors focus too much on the black and white of the law and not enough on the grey areas. And at Balfour+Manson, what we like to do to really add value for clients is get into the grey areas and find solutions that maybe others wouldn't think of.